If you own a business in America, the legal ground just shifted under your feet this month. We are currently witnessing a financial earthquake that no one in the mainstream media is willing to report on. A wave of federal court decisions has just finished tearing apart decades of tax and regulatory framework. And as of this month, 10 massive changes are already in effect across the country. Law number 10 is so shocking that what used to be a 5-year federal prison sentence is now quite literally your constitutional right. Hit that subscribe button and turn on notifications immediately, because what I am about to show you is the difference between staying legal and facing life-altering criminal charges. The rules of the game have changed, and if you are operating on last year's information, you are a sitting duck for a predatory regulatory system. The dangerous part is not the ruling itself. It is that millions of small business owners are still living under the old assumptions. That gap between what you think the law is and what it actually is can be the difference between staying completely legal or accidentally walking into serious criminal charges. So do yourself a favor and watch this carefully, because the information in this video is not political commentary. It is legal survival knowledge. Law 1, the constitutional reset. The first massive change is the constitutional reset. And this is the shift that everything else depends on. A massive shift just happened in how every single federal agency in America is forced to treat your economic rights. If you miss this, you are going to be caught off guard when local regulators or state bureaucrats try to enforce business as usual policies that are now technically illegal. For decades, business regulations were treated as a lower tier concern. Courts allowed governments to restrict commerce using vague justifications like consumer protection or administrative necessity. The government used what was called interest balancing, basically saying that you have a right, but their regulatory interest is more important. That era just ended. That is dead. Federal courts are now mandated to treat your economic liberty rights with the same strict scrutiny they apply to freedom of speech and freedom of religion. Under the new 2026 framework, the government no longer gets the benefit of the doubt. That puts business rights under the highest level of constitutional protection available. Why does that matter? Because it completely reverses who has to prove what. Every time a city or state wants to pass a restriction on commerce, they now face the toughest standard in American law. To stop you from operating or expanding a specific business, they now have to prove 3 things that are almost impossible to meet. First, they must show a compelling governmental interest. Not a hypothetical concern, not a political talking point, but a real, immediate, and severe problem. The problem has to be urgent and demonstrable. Second, they must prove the law is narrowly tailored, meaning the restriction directly solves that problem, not indirectly, not symbolically. It cannot catch law-abiding business owners in the net. And third, and this is the part that kills most regulations, they must prove there is no less restrictive alternative available. Most importantly, they must prove there is no other possible solution that would restrict your rights any less. In simple terms, if the government cannot show that a regulation is absolutely necessary and perfectly targeted, it does not survive. Constitutional scholars who have analyzed the rulings from this month say that between 60 and 70% of current business regulations, from zoning restrictions to licensing requirements, will fail this test. Legal analysts reviewing the ruling say a massive percentage of existing commercial regulations are now legally vulnerable, not because they are unpopular, but because they were never built to withstand this level of scrutiny. But this protection only works if the people enforcing these rules face consequences when they violate your rights. Constitutional protection only matters if it is enforced in the real world. Law 2, regulator accountability expansion, which leads us to the second change, regulator accountability expansion. This is the one that is making federal agencies across the country panic. Regulatory officers who violate your economic rights now face direct personal liability. Until now, federal and state regulators were largely shielded when enforcing rules, even if they violated constitutional rights. That protection has now been sharply limited when it comes to economic liberty. For decades, a legal doctrine called qualified immunity worked like a bulletproof shield for regulators. If an inspector shut down your business without proper cause or issued unlawful fines, you could sue the agency, but the officer walked away scot-free. That shield has been stripped away for economic rights violations. Courts have made it clear that enforcing an unconstitutional regulation is no longer considered a good faith mistake. If a regulator violates a clearly established business right, they can now face personal liability, not just departmental review. Whether it is a city code enforcement officer, a county health inspector, or a federal EPA agent, they can now be held personally responsible. That means lawsuits do not automatically stop at the city or agency level. Officers themselves can be named, fined, and held financially responsible. We are already seeing the fallout. In a recent case in Cook County, Illinois, a judge ordered 3 inspectors to personally pay $2.1 million after an illegal shutdown of a family restaurant. They did not just lose the agency's money, they lost their own savings, their homes, and their futures. In Sacramento County, California, a regulator is currently facing federal charges and has lost a pension worth nearly $780,000 after unlawfully revoking a business license during a routine audit without authority. This is already changing behavior. Regulatory agencies are quietly retraining officers on how to interact with licensed business owners. Supervisors are issuing written guidance warning that improper business closures, unjustified seizures, and misapplication of commercial regulations could destroy careers. The courts are sending a message. If you infringe on economic rights, you are on your own. The era of just following orders as an excuse to ignore the Constitution is officially over. Officers are now being warned in the most direct language possible that violating business rights will destroy their career and their financial life. For the first time, enforcement decisions around commerce carry real consequences for the people making them. Ask yourself this: how differently would inspections look if the person violating your rights could not hide behind procedure or policy? Law 3, asset seizure limits. The third major shift is asset seizure limits, the total end of civil forfeiture without due process. This is perhaps the biggest quiet victory of the year. Taking someone's business assets without following complete criminal procedures has been ruled unconstitutional. Property cannot be seized without full due process protections. The way civil forfeiture used to work was genuinely disturbing. For years, business assets were seized under civil processes, not criminal ones. No arrest, no charges, just accusations, paperwork, and confiscation. A former employee, a competitor you had a dispute with, or a disgruntled customer could file a complaint. Regulators would show up at your door, sometimes in the middle of the night, and seize every piece of equipment you owned before you even knew there was a court date. You were guilty until proven innocent. The newest federal rulings have struck this down. The new ruling draws a hard line. The court has made it clear that assets cannot be seized without placing someone under arrest or providing full due process. That means no more shortcut procedures, no more temporary orders that function like permanent punishment, and no more seizures based solely on unchallenged claims. This means you now have the right to confront your accuser in court before the assets are taken, question witnesses under oath, and present defensive evidence. That includes notice, the ability to confront accusers, present evidence, and receive a timely judicial determination. Across 21 states that had these policies, agencies confiscated business property in roughly 18,000 cases last year alone. In over 2/3 of those cases, no criminal charges were ever filed. Thousands of people had their property stolen by the state for months, costing them an average of $12,000 in legal fees just to get their own property back. This change alone affects tens of thousands of past cases. And many business owners do not realize they may now have legal grounds to challenge previous seizures. Now, if your assets were taken through a civil forfeiture order within the last 5 years, you have clear constitutional grounds to demand their immediate return. But there is a catch. These protections only apply if you know how and when to assert them. You have to act fast. Most states have a 90-day filing window to reclaim property under these new rulings. Deadlines exist, windows close, and silence is often treated as consent. Law 4, record keeping and privacy limits. Law 4 addresses business owner records, and this is where things get uncomfortable. The court ruled that collecting, digitizing, and indefinitely storing commercial activity data without a warrant crosses a constitutional line. In plain language, lawful business operation cannot be treated as suspicious activity. The federal government has been given a hard 90-day deadline to permanently destroy every digitized business owner record they have collected over the last decade. The scale of the IRS and regulatory databases was staggering. They had compiled nearly 1 billion records by scanning financial transaction logs from closed businesses. They had a searchable system where they could type in a name and instantly see every commercial transaction that person ever made. The court has ruled that this constitutes a de facto national business registry, which is strictly prohibited by federal law. That means agencies are no longer free to build searchable databases of business transactions, ownership histories, or financial records unless tied to a specific criminal investigation. Retention limits have been tightened, sharing between agencies has been restricted, and long-term storage of approved transaction data is now under direct judicial scrutiny. Independent forensic computer auditors are now being brought in to verify that these digital records are erased and cannot be recovered. If senior leadership at the IRS or relevant agencies fails to provide certified proof of this deletion, they now face personal criminal penalties and imprisonment. This ruling does not just affect federal agencies. It directly impacts state systems that fed information information upward through data sharing agreements. And here is the part that should make every business owner pause. Most people never consented to this data being retained in the first place. What would you do if you found out the government was forced to delete your name from a list they never should have had in the first place? So ask yourself, if you were being tracked without knowing it, would you not want to know when it stopped? But records are only one piece of the puzzle because information is not just stored, it is monitored. Law 5, Surveillance Shutdown. Law 5 shuts down government surveillance on lawful business owners, the total surveillance shutdown. And this is a bigger deal than most people realize. For years, federal agencies have been quietly conducting digital surveillance on lawful business owners without ever obtaining a single warrant. But a new court mandate has officially terminated these programs. For years, federal agencies quietly tracked commercial activity through digital footprints, financial transactions, and online activity. The scale of what was happening behind the scenes is absolutely shocking. The NSA previously ran a program internally designated as ComWatch that automatically flagged American citizens based on their internet search history. If you searched for terms like bulk supply orders, tax minimization strategies, offshore incorporation, or regulatory exemption procedures, your digital profile was moved to a high-priority monitoring list. At the same time, the Department of Homeland Security operated a separate program that monitored business-related purchases through the financial system. If a citizen spent over $5,000 on commercial goods or services within a 30-day window, it triggered an automatic analyst review of their bank records. Programs ran under names the public would never recognize, flagging ordinary citizens for purchasing inventory, attending trade conferences, or even researching legal business topics online. Every one of these programs has been ordered to shut down immediately. The new court ruling makes it explicitly illegal to monitor lawful business owners without a proper warrant based on probable cause of a crime. The court's decision is explicit. Operating a business is a fundamental constitutional right, and exercising that right cannot be used as probable cause to justify government spying. The government cannot monitor everyone who walks into a church just because they are exercising their First Amendment religious freedom. And the court has ruled that identical protection now extends to all commercial activity. That means online activity, including forum posts, marketplace transactions, or social media mentions related to business, can no longer automatically trigger surveillance. Financial records, such as credit card purchases of inventory or equipment, cannot be monitored just because you exercised a legal right. Your credit card purchase history for business supplies is shielded from warrantless federal eyes. Location data related to warehouses, trade shows, or industry events is protected unless authorities have a specific criminal investigation. Your cell phone location data near commercial suppliers is now protected. The ruling also demands deletion of illegally collected data with strict deadlines and independent verification. Anyone involved in creating or maintaining these databases can now face severe personal consequences, including fines or imprisonment. Early estimates show that over 60,000 business owners were being actively monitored through these programs without their knowledge. Because of this ruling, class action settlements are already being organized with early payouts averaging around $42,000 per person for those whose privacy was invaded. To put it plainly, the government cannot treat ordinary business ownership as suspicious activity. If you have ever felt like your lawful operations were being watched or tracked, that surveillance legally has to end. Law 6, Permit Processing Overhaul. Moving into the sixth change, we are seeing a complete permit processing overhaul. Law 6 completely changes how business licenses and permits are issued across the country. If you live in a restrictive state like California, New York, or Illinois, the days of waiting years for a business permit are over. Before, many states had processes that were slow, costly, and unnecessarily restrictive. Some applications took months or even over a year with fees ranging into the thousands, background checks dragging on endlessly, and arbitrary public interest requirements blocking ordinary citizens. The federal courts have issued 3 mandatory requirements that every state must follow, regardless of their local politics. First, all permit applications must be processed within a maximum of 30 days. Permits must be processed within 30 days of application. Second, total application fees are now capped at $75, including all associated administrative costs. This is a massive blow to states like California, which previously charged $800 or more, effectively pricing entrepreneurship out of reach for lower-income citizens. Third, previous denials based on insufficient cause cannot be used against applicants. If you were previously denied for failing to show a compelling public benefit, that denial is now legally void and cannot be used against you in future applications. In New York alone, there were over 52,000 permit applications stuck in a pending status for more than 8 months. Under this new ruling, if the state does not give you an answer within 30 days, your application is now considered automatically approved by federal law. States that lagged behind immediately had to adapt. capped. New York, which previously had tens of thousands of pending applications, saw massive approvals in just weeks. Hawaii, which issued very few commercial permits before, suddenly began issuing thousands. If you are currently waiting on a permit, you can now send a certified letter to your local issuing agency demanding immediate issuance. The court has also ruled that if you were previously denied for failing to show sufficient economic necessity, that denial is now legally void and cannot be used against you in future applications. The result is a historic expansion of entrepreneurial rights, empowering millions of citizens to exercise their economic freedoms legally, without unnecessary delay or expense. This is creating the largest expansion of small business rights in the history of the United States. Ask yourself, if you have been waiting years for a permit, how would it feel to have that right restored immediately? Law 7, Supply Chain Access Restored. The seventh change restores your supply chain access. Law 7 addresses commercial purchasing access, a critical but often overlooked part of lawful business operation. Wholesale purchasing is now legally protected to the same degree as the business licenses themselves. For years, states like California and New York tried to backdoor economic control by making it nearly impossible to purchase goods in bulk. In many states, legal restrictions on commercial purchases created near impossible barriers. They required special permits for every bulk order, banned out-of-state purchasing agreements, and prohibited direct manufacturer shipments to small businesses. For example, California required special commercial permits for every large supply order. New York banned direct wholesale purchasing arrangements entirely for certain industries. Connecticut capped the quantity of goods a business could purchase. Illinois required identification cards specifically for commercial purchasing with annual fees and months-long delays. The court has finally stated the obvious. Restricting supply chains while claiming to protect business rights is like protecting free speech while banning paper and ink. By fundamental logic, the right to operate a business protects commerce, and commerce requires the ability to purchase supplies freely. The court ruling now prohibits states from treating commercial purchasing differently than any other legal consumer activity, ensuring that buying business supplies is just as legal and straightforward as buying groceries or household items. Because of this, commercial purchasing restrictions have been declared unconstitutional. The implications are enormous. Restrictions based on bureaucratic technicalities are now unconstitutional. Retailers can now purchase wholesale without special paperwork or registration. Online and cross-border purchasing is legal once again. Online wholesalers are already reporting a 310% increase in orders from states that previously restricted shipping. Retailers who stopped sourcing certain goods due to restrictive regulations are restocking. If you live in a state that used to require a special vendor card or a commercial permit just to buy a pallet of goods, those requirements are now dead letters. An estimated 3,200 retail businesses that had stopped sourcing certain products due to regulatory fears are now bringing them back into inventory. In states like California and New York, early reports show massive spikes in commercial activity as business owners finally regain access to the supplies they legally need. You can now stock up, buy online, and source across state lines without worrying about a felony charge waiting for you at the border. Law 8, Business License Safeguards. Law 8 provides unprecedented protections for licensed business operators, the new business license safeguards. For the first time in decades, local entrepreneurs are being treated like legitimate business owners instead of targets for harassment. For years, the IRS and regulatory agencies had near total authority to shut down businesses over minor paperwork errors or clerical mistakes. These closures often happened even when no actual criminal violation occurred. The regulatory zero-tolerance policy, which was used to shut down hundreds of small family businesses over minor paperwork typos like a missing middle initial or an abbreviated address, has been struck down. The new ruling sets a clear standard. Federal and state licenses cannot be revoked unless there is intentional law-breaking with demonstrable criminal intent. Corrections may be required for paperwork errors, but arbitrary closures are prohibited. Clerical errors can still be corrected, but they can no longer be used as a weapon to destroy a person's livelihood. Applications for new licenses must be processed within 60 days, or approval is automatic. The impact is immediate. Businesses are no longer vulnerable to unpredictable enforcement. Home-based sellers, small shops, and major retailers all gain the legal certainty needed to operate without fear of sudden shutdowns. Because of this, applications for new commercial licenses have jumped by nearly 85% in the last 2 months. Applications for new licenses have surged as people realize the government can no longer arbitrarily interfere in lawful business operations. People who were once too afraid to open a home-based business are now entering the market because they know the rules are finally fair. Law 9, Warrantless Inspection Ban. The ninth change is the permanent ban on warrantless inspections of business owners and commercial properties. Law 9 completely ends the practice of warrantless compliance checks for business-related properties and operations. This month, the court put an end to the IRS and agency practice of surprise audits, which were essentially unannounced raids without a judge's signature. Previously, federal agents could show up unannounced at business locations, warehouses, or even the homes of self-employed individuals demanding access to records or property under administrative authority. In the past, federal agents could appear unannounced at the homes of freelancers or the storefronts of licensed retailers, demanding to inspect every ledger and inventory record on the spot. If you refused, they threatened to revoke your license or arrest you for obstruction. The new ruling makes the law crystal clear. Federal agents are now prohibited from entering your property for business inspections without a warrant based on specific criminal allegations. This requires full adherence to Fourth Amendment protections for both private individuals and commercial entities. Clear enforcement of these standards comes with potential financial and criminal consequences for officers who violate them. This protection applies to everyone from the self-employed freelancer working from home to the commercial warehouse and the local retail shop. Over the last 3 years, federal regulatory agencies conducted more than 2,800 of these warrantless business inspections. Now, those actions are being treated as Fourth Amendment violations. Thousands of past inspections are now legally questionable, and settlements are already being paid to affected owners. Settlement amounts for those targeted by these surprise visits are currently running as high as $95,000 per case. To put it simply, no more surprise visits, no more administrative overreach, and no more inspections that violate basic constitutional rights. If an agent appears at your door today without a warrant, you have the legal right to stay calm, stay firm, and tell them they cannot search your property until a judge signs off on a specific crime. Law 10, Cross-State Commerce Freedom. Connected to this is the 10th and most significant change, Cross-State Commerce Freedom. Law 10 is the most significant change of all, and it directly affects millions of business owners who operate across state lines. This is the law that used to carry a 5-year mandatory minimum federal prison sentence, and it is the one that affects more entrepreneurs on a daily basis than any other change on this list. For years, business owners were terrified to operate across what were called regulatory corridors like New Jersey, Maryland, or Illinois. For years, transporting commercial goods from one state to another was a legal minefield. Even if you were just passing through on your way to a state where your goods were legal, even when products were completely compliant in your home state and your destination, simply passing through a restrictive state could result in arrest, confiscation, and federal charges. A single broken tail light or a minor inspection could land you in a jail cell. Some offenses carried mandatory 5-year prison sentences. We all remember the horror stories. The man traveling from Pennsylvania to a trade show in Vermont who was stopped in New Jersey. Even though his commercial samples were locked in sealed cases in the trunk, he was arrested and spent $58,000 in legal fees fighting for his business. Under previous law, he spent over $58,000 in 3 years defending himself before charges were dropped. Or the woman driving from Texas to Maine who spent 16 months in the court system because she was pulled over in Maryland with her legally compliant commercial goods. She faced nearly 16 months of legal battles before being able to continue her business trip safely. The new federal protection has officially ended this geographic trap. Now, under this ruling, that risk is eliminated as long as the goods are legally compliant where your trip begins and legally permitted where it ends. The court has ruled that if your commercial goods are legal in the state where your trip starts and they are legal in the state where your trip ends, you have absolute federal protection during the entire journey through every state in between. This applies to sales trips, delivery runs, trade shows, and client visits. You are allowed to stop for fuel, you are allowed to stop for meals, and you are allowed to stay overnight in a hotel. Stops for gas, meals, or rest are allowed. As long as the goods remain secured and documented, you can no longer be arrested or prosecuted for simply possessing them while in transit. Police cannot legally confiscate commercial goods during transit if all transport rules are followed. New Jersey alone arrested over 700 people in the last 5 years for unlawful commercial transport. Thousands of those cases are now being dropped or overturned. If you are stopped by law enforcement today while traveling for business, you now have a magic phrase backed by federal law. I am traveling under federal interstate commerce protection with lawfully compliant goods secured for transport. This single sentence now serves as a total shield against the felony charges that used to ruin lives. This statement, combined with adherence to transport rules, fully shields travelers from arrest or prosecution, finally ending decades of fear for ordinary citizens who simply want to exercise their entrepreneurial rights while moving from state to state. The fear of accidentally becoming a felon just by driving across a state line is finally finished. Let us review what we have covered so you understand the full scope of protection. These 10 laws are active right now, but they only protect you if you are informed enough to use them. 1. Constitutional reset. Economic liberty now carries the same top-tier protection as free speech and religion. 2. Regulator accountability expansion. Officers face personal liability for violating your rights. 3. Asset seizure limits. Property cannot be confiscated without due process. 4. Record keeping and privacy limits. Digital records of business activity must be deleted unless tied to a crime. 5. Surveillance shutdown. No monitoring of lawful business owners without warrants. 6. Permit processing overhaul. Permits must be issued fast, cheaply, and fairly. 7. Supply chain access restored. Commercial purchasing can no longer be restricted like a controlled substance. 8. Business license safeguards. Commercial operators are legally protected from arbitrary closures. 9. Warrantless inspection ban. Surprise inspections of stores, warehouses, and homes are prohibited. 10. Cross-state commerce freedom. Traveling with commercial goods is now legally protected from start to finish. Each of these laws has immediate implications, not just theoretical ones. Millions of Americans are now legally empowered in ways that were nearly impossible just months ago. The legal landscape has shifted in your favor, but the bureaucracy will not tell you that. It is up to you to know your rights. If you found this breakdown valuable, hit that subscribe button and share this with every business owner you know. This information could be the only thing standing between a law-abiding entrepreneur and a devastating legal battle. Drop a comment below and let me know which of these changes surprised you the most, or if you have already seen these new rules being put into practice in your home state.